On to our big focus this evening. The spotlight is squarely back on the sedition law, with the JNU case back in the headlines and the case of a Manipur journalist being sent to 1 year's detention. Now, close to 3 years after an FIR of sedition was registered against students of Jawaharlal Nehru University for allegedly raising anti-national slogans during an event on campus. The Delhi Police's special cell has finalized the draft charge sheet in the case, and it names Kanhaiya Kumar, Omar Khaled and Anirban Bhattacharya as the main accused. 8 others have been named, all from Kashmir, and the police apparently collected evidence after scanning the social media profiles of some of the students. In the other case, the Manipur case, the journalist, the man you see on your screens, Kishore Chandra Wankham, was sentenced to a year's detention under the National Security Act after he was taken into custody for allegedly targeting the ruling BJP in the state and Prime Minister Modi in a social media post. Now, Mr. Wankham had reportedly quit his job with the local news channel before posting those controversial remarks on Facebook. We're asking this evening whether disagreeing with the government amounts to sedition, why the colonial era law continues to be misused by government after government. Is it in fact at odds with the citizens' right to free speech, or are there larger considerations of national security that still need to be taken into account? Joining us this evening, N. Sai Balaji, President of the JNU Students' Union, Deshatan Nigam, political analyst and lawyer, is with us, and Aryama Sundaram, senior advocate in the Supreme Court, is also with us. Aryama Sundaram, let me begin with you. In your opinion, do you believe that sedition law should have been applied in either of these cases?
No, I certainly believe it should not. In fact, let's not forget what the whole sedition law was really about. It was a law which was brought in case of a country which was an empire which was trying to rule various colonies, and were afraid that those colonies will try to get their independence away from the empire. The basic rule of sedition law was, if someone tried to remove the government, not the government as in the government of the day, but the whole concept of democracy, to destabilize the governing of the country, to revolt against the government, against the country as such, to support another country revolting against the country, or yourself revolting in order to rid the country of its system of the constitutional rule, to support any other country coming in. This was the basic idea. It was basically an anti-national idea. It is nothing to do with anti-government of the day idea. Right. You are free to criticize the government of the day. You are free to even make moves to destabilize the governing party and see that another party comes in place of the governing party. What you can't do is destabilize the process of governance. Right. That is something you cannot do. And that takes a very, very far-reaching kind of act. Don't forget, even the British, in many cases of sedition, which were filed against various Indian nationalists, the British courts actually held in favor of the Indian nationalists in many of those cases, saying they don't amount to treason, they amount to voicing an opinion. And I'm afraid that the way it's being used nowadays by all political parties, it's an anathema to any right of freedom of speech. And freedom of speech itself is the backbone of democracy. And democracy itself, as you know, is the very basic structure of our constitution.
All right, Deshatan Nigam, let's reflect upon the point that Aryama Sundaram makes about, anti-national as opposed to anti-government. Can disagreeing with the government of the day amount to sedition under any law at all? And, it's not just the present government. Why is it that government after government has been so resistant to the idea of revisiting this law?
One thing, Mr. Sundaram clearly pointed out, and I do agree with him, that anti-national and anti-governance are two separate things, and this law needs clarification. And however, its constitutionality has been upheld by the Supreme Court in number of judgments, whether it is Kedarnath Singh or Balwant Singh judgment. So, but however, they have restricted the scope, saying that if it is anti-national, if it is inciting violence and public disorder. So they very clearly said, even casual, slogans like Khalistan Zindabad were not considered to be seditious in the case of Tara Singh. So therefore, we are only concentrating on 124A of the IPC, but the real law lies in section 203 of UAPA Act of the Unlawful Prevention. There it talks about national integrity. talking about breaking India. This is where the actual law is. You need to, have some kind of an integrated approach to the law and take out the anti-party or anti-government stand out of it and bring that aspect of it into this law.
But you're saying that as it stands, Section 124A of the IPC, and that's on our screens right now, it says whoever by words, either spoken or written, or by signs or by visible representation or otherwise, brings or attempts to bring into hatred or contempt or excites or attempts to excite disaffection towards the government established by law in India shall be punished with imprisonment for life, or which may extend to 3 years imprisonment.
No, this has been interpreted in a different way by the Supreme Court in Kedarnath case, and they have restricted casual slogans and things like that are now no more considered as seditious.
How would you say that this applies really to the JNU case? The timing of this, the fact that we're hearing that the Delhi Police Special Cell is now ready with its draft charge sheet.
I'm amazed.
And it's 3 years. It's 3 years in what the government had claimed originally was a fairly open and shut case. There was footage available. There were all of those things were talked about at great length at the time. N. Sai Balaji, you're the president of the JNU Students' Union right now.
If I have to start, I'll have to start from where a senior advocate has left. The era of the legacy of sedition comes from the British era. All the Indian nationalists, be it Tilak, be it Bhagat Singh, they were slapped with sedition. Today, the same law, even after 70 years of our independence, it's unfortunate that the word sedition itself is an antipathy to our democratic constitution that we have established. The reason why I'm saying is, we have come into an era after the British colonial legacy where there were great inequalities in the society, be it untouchability, be it gender equality, be it economic disparity. Any person raising these concerns would definitely mean speaking against the present dispensation.
Right. No, without going into all the history, would you say right now this is just archaic and this is something that needs to be reviewed?
It should be repealed immediately. The reason I am saying is, going by what the professor has been saying, even let's assume the slogans have been raised for a matter of fact, which they were not raised, which have been repeatedly told by the magisterial committee, a magisterial report which Delhi government placed. Even let's suppose the slogans were there, they are not seditious. And why should a government be afraid of slogans? I am afraid. I raised an anti-Modi slogan. My MPhil has been blocked today by my administration. I am amazed by the kind of sagacity they are having, audacity I would say, to punish people who are anti-government. This only shows one thing, which if you give me a minute, I would like to address. There is a great economic crisis that's happening in this country. There are no jobs. Farmers are under distress. There is no safety for women. Dalits who have been fighting for their rights.
Okay, so are you effectively then saying that this is an attempt, you're saying,
silence,
to take away from all of that?
Exactly. What happened in Bhima Koregaon incident?
Okay.
What happened in Bhima Koregaon incident?
Respond to this, because this is a point that actually a lot of people are making. Shaila Rashid has tweeted, and if we can get that tweet up on our screens, when the BJP kept playing the anti-national card, JNU Ramjas, it kept winning state elections, she says, in Assam, Uttar Pradesh, etc. Now, after facing defeat in state assembly polls, the BJP pulls out the forgotten Trump card for 2019, as it is #0 on farmer issues, economy, etc. This is the challenge that is being thrown to the government right now. How do you respond?
Not at all. See, we all saw those videos where they talked about Azadi, Banduk se lenge Azadi, tukde tukde. These are not casual. This thing.
But did those videos show Kanhaiya Kumar, who's been named
absolutely not.
So
in the draft charge sheet as being there?
We have to see what charge sheet is being filed. It is still in the draft stage. What evidence they support, because they said they went into investigation, they collected other evidence, so we have to wait for that. So you can't say that as of now.
We also cannot say as of now. Exactly.
That is what, so let's wait for the charge sheet. I said
sedition
with investigation. Now, please hold on. Don't interrupt. I didn't. So the fact remains. The law has been interpreted by Supreme Court. It has been restricted. There are other laws. You have to see in whole. There is a Seditious Meeting Act of 1911, which is there, along with UAPA Act, where the real definition is there. So this law as of now does not stand the way you read it. It has been restricted.
My point is, but the sedition law is also being reviewed by the Law Commission of India.
Yes,
is that not correct?
124A.
124A is being reviewed,
not
and stakeholders
UAPA,
are being asked for their...
If you can just allow me 30 seconds.
So we are there in UAPA. UAPA is not under review. That's the real law where you talk of breaking India, where you talk of, I am sure in the charge sheet, if there are evidence, those...
Okay,
30
Balaji is
seconds.
clearly disagreeing with that. Let's just get his point in.
Just 30 seconds. In this country, we are seeing how lynch mobs are being persecuting
Don't
people.
politicize
Please.
Let
Let me listen. Let me listen.
No,
Let me listen
you've
to
been
me.
going to farmer
Please.
suicide. You've been,
No.
I
In
don't
this
know,
in this New Delhi itself, the Indian Constitution was
trivializing the whole
burnt.
issue.
Indian Constitution was burnt. People are lynch mobs are going and killing people on the spree. Sedition is never applied on them. They are actually breaking the society.
That comes in the different domain of criminal law.
The reason sedition is
cannot be
always
applied
used
for mob
is to
lynching.
silence dissent, because that is the worst a state can do, where they have to actually punish people who are actually breaking the society. Why is Shambaji Bhinde, who is accused of violence in Bhima Koregaon, being freed of all charges right now?
Okay, fair enough. Let's refer to
court
the
does
other.
it, not
Okay,
us.
let's just refer to the other case also, because this isn't just about JNU. A Manipur journalist posted a video on Facebook, Aryama Sundaram. It may have been a bit of a rant. But did it constitute such a threat that he ought to have immediately got detention for 12 months?
According to me, no. According to me, certainly not. Preventive detention of any nature is a very draconian provision. In fact, preventive detention is again, a complete antithesis of any democratic rule of law. It is, however, used in certain cases. Like in England, for example, you can use preventive detention at the time of war, when you're worried about somebody being, let's say, a suspected spy or anti-national in some way. But to use preventive detention the way we have in India, if you remember, we had Maintenance of Internal Security Act, we've had the various NSA acts, we even had Coffee Posa for economic offenses. So I think in India we have carried preventive detention exceedingly far. Unfortunately, these statutes have all been upheld by the Supreme Court. But the point of it is, sometimes the danger is really in the application of those acts, not in the acts themselves. And it's really the sting is in the tail. Now look at this particular case. What was really done was, it was an out-and-out criticism of the government. Maybe intemperate language was used. Maybe extreme statements were made. But the fact was, it was an out-and-out anti-government of the day statement, which was certainly not seditious. I'll give you a small example how dangerous this becomes. Let's say a man is, let's say he's impoverished, he's not able to get a job, he's starving, his family is starving, and he turns around and says, India is a terrible country, it's the worst country to live in. I wish I was not an Indian, I wish I was not in India. Now can you say that is sedition? It is certainly not seditious. Sedition requires something more. It requires an act of treason whereby you are willing to use force, or you're willing to create kind of public disorder to overthrow a government and bring in an anti-constitutional government. When we refer to government of the day as constitutionally elected, what we're referring to is we're talking about a government as the Constitution contemplates,
right.
That kind of government.
Right.
If you want to really disrupt the Constitution itself, then you can say that is seditious, but not otherwise.
But why do you think, Aryama Sundaram, that successive governments have been quite so reluctant to do away with what appears to be so archaic and so out of touch with the times?
They have the power to punish people.
Well, I will say one thing. To have a law of sedition per se, for what it actually means, that someone cannot start plotting with another country on coming and trying to overthrow the government of India, throw out our constitution and take over the country altogether. Now that is certainly an act of sedition, and I think in any country in the world,
right.
Such an act will go punished. That is, if you're going to revolt against your own constitution,
you make the point about the danger
support
being
an
in the
enemy to come and conquer your own country. Now that is an act of sedition. But the point is, the law per se cannot be faulted. The application of the law,
right.
the interpretation of the
So
law,
is that something
the
you would
law
agree with,
as it stands today, the way it's capable of being so misinterpreted
Yes.
by governments is
Yes.
what's wrong.
So the danger lies in the application then,
Absolutely.
Balaji.
The reason why, if someone commits a crime of that nature, you don't need a sedition law to punish them. There are enough laws to punish them. Why to have an archaic law that is
So
there?
I think Deshatha
I think
Nigam,
the
that
point-
seems to answer your argument as well. You know, you're talking about the UAPA and any number of other laws. Why then invoke the sedition law in these cases in any case?
See, sedition law has been interpreted accordingly. Those portions which were archaic of the British time have been done away with by interpretation of law by the Supreme Court, and therefore its constitutionality has been upheld in the restricted sense, not in the sense of the British times. So therefore, even today, you have the last section in IPC, which is 511, to attempt to commit an offence, it is itself an offence. So when you start slogans, also you have started taking an attempt, so that the offence starts from there, and then UAPA, and I'm sure when the charge sheet comes,
But I have to get back to my original question. Does disagreeing with the government
not.
amount to sedition?
No. I don't.
But
think-
isn't in both these cases, isn't that what appears
No,
to be?
I
Give me
make
a
a distinction
moment.
between JNU. There are very clear signs of sedition as interpreted by the Supreme Court.
They are doctoral
About that the court will see, and
how is
and
the
at the end of the day,
validation
I don't have the complete facts about the Manipur, so I am going to restrict myself to JNU.
No.
That's-
I mean, that's a political statement.
No,
The
it's
reason why
not,
I'm
because I
saying is
actually don't have exact
Kerala High
facts
Court,
that has happened.
Kerala High Court has reinstated a professor who was removed by the Central University of Kerala for writing a post against the government.
There have been so many
That-
instances.
exactly.
In Bengal, there's been,
Exactly.
the professor Ambikesh Mohapatra who
The
was
reason I'm trying to
jailed for
say is-
circulating
No,
a
if
cartoon about Mamata Banerjee. So
No,
it's
no,
not
no, no.
about the center or...
Yeah, it will.
What I'm trying to say
when
this is
application-
clearly used
see,
as
when
a tool by
when-
governments
see,
across the
what I'm
political
trying to-
spectrum.
why- what I'm
when
trying to
the
say is-
exactly the state misuses, we
Kerala High
have
Court-
the courts to look after, and this has happened in US also, the best democracy that
Kerala
you
High
call.
Court
If it is
clearly in its
misused,
state-
the
clearly in
courts
its
are there to
judgment.
punish those people. And
Kerala High
you
Court
must
clearly in
trust
its
your-
Okay,
judgment.
last words on this discussion. I have to wrap this up to you, Arya Masundaram. As we've been saying, there have been attempts to review this, the Law Commission of India doing so, but there have also been proposals to actually strengthen the sedition law as well. And then, there are those who say that showing disrespect to the nation should actually be added to the definition of sedition, as it were. How do you respond to proposals like that?
Well, I respond very negatively because I feel the sedition law as it stands is itself being interpreted in such a wide manner. It really is hitting democracy itself. And if you want to make it even wider, it's very unfortunate. If you say disrespect, we have different enactments. We have the National Flag Act, where if you show disrespect to the national flag or show disrespect to the national anthem, then those are different punishments. But to bring it under sedition, I think is horrific. And according to me, the sedition law, because today it is being so misapplied by all governments which are in power, I think it's time to scrap the law and make it very clear. Waging war against the government of India, waging war against India is punishable. Otherwise, let's not go in for interpretations by governments of the day which make it completely undemocratic
All right,
and
I'll
anti-democratic.
have to.
I
Yes.
only want some clarification in the law.
Right.
As it is, it should be clarified,
Okay.
and
That you
and
cannot
that
raise
would make
anti-Modi slogans.
things simpler.
All right. We leave it at that for the moment. I'd like to thank all of you for joining us on this discussion.